Buenos días de nuevo.
Good morning again. For this second part of the second day of the doctoral seminar, Charles V European Awards, Antonio Tajani, the European Union and the Principle of Solidarity. This panel is chaired by Dr. SUSANA del Rio. She has a PhD in political science, an extraordinary PhD award in social and legal sciences, and an academician of the European Academy of Science and Arts in Salzburg, the director of the Integral European Union Program of Deusto Business School, director of the WG Convention of the Future of Europe, academic advisor to FIDE, and author of 3 books on European politics. She is a peace ambassador for the Women's Association for World Peace, which is part of the European Secretariat for Women. Today is the day for the elimination of violence against women. She's a member of the European Commission's Committee of Experts in Citizens and Governance, and a European professor in the master's degree of the Center for Political and Constitutional Studies, director of the Institutional Relations of Citizens for Europe, and columnist for El Correo. Sometimes I wonder where you find the time to do all these things, but I'm glad that you do. Susana is a Europeist woman. She keeps on doing research and working in all these places. She holds all these positions now, so she's currently working in all those places. So thank you for contributing to the European integration and the creation of more Europe that we all work for. So thank you for taking part in this seminar. Maybe your first time in this seminar, even if you have worked for us in many other courses and publications. So I hope you will like it, and finally you will be able to contribute with ideas. Thank you, Susana.
Buenos días.
Good morning, everyone, and thank you, Miguel, because this is really, as you have said, being together with the Yuste family, and after 20 years is a pleasure. I've taken part in many of the events and courses they organize, and it's an honor for me. And I wanted to say, and I say it every day, that being here, the Parador de Jarandilla, and having the opportunity to go to the monastery this afternoon is always inspiring to me. I always think this is so European, so inspiring. This is such a big team, such a good team. It is a pleasure always. I want to thank Juan Carlos Moreno, Teresa Freixes, my teacher, my master, my flag, for so many years, because she was the president of the commission that evaluated my PhD thesis. And Miguel Angel is a non-stop worker. Special thanks to the members of the jury and to you all. Being here is especially important because we learn from you. I love debating, I love discussing, I love what we are creating together. This is the way ahead. My perception, as Miguel was saying, about this seminar is obvious. I am talking about it in the social networks, and I am talking about it, I'm publishing about it because my opinion about this seminar is excellent. My opinion about you is excellent. Everything is very enriching, you and the members of the jury. I loved having the opportunity of presenting the work by Nuria Ferre, because She's an excellent researcher and academician, but something struck me from the beginning when I first read about her. She's an activist. The topic she does research on. Nuria Ferre studied law and business administration at ICADE, the Comillas Pontifical University. She also studied a master's degree for access to the legal profession and a master's in international migration. In October 2021, she publicly defended her doctoral thesis on the right to asylum and borders. And I was struck to see that, and I feel proud of you, Nuria. I feel proud that I am in charge of presenting your work, because you have worked as a the border in Ceuta and Melilla, in Lebanon, Iraq, Jordan, and Syria. And I loved it, because you've also worked at the Entre Culturas Foundation, and you currently work as Head of Studies and Research at the Spanish Commission for Refugee Aid, CEAR. Your work is so interesting, so important, but I'm going to focus on Nuria's work, because this is a very hot topic that intertwines the fundamental rights, human rights. I like your analysis about how there is like synchronization of the time in which the European Union is always permanent thinking about the Schengen area and the opening of the inner borders. But what about the outer borders? Why are they closing them? Why there is a European Migration Covenant launched by the European Union a few months ago? A la carte, personalized, customized. I don't think that is the migration pact that the European Union deserves. European Union means European integration. And Nuria, you will talk about the integration process in your presentation. You will mention it a few times, and you will analyze the problems of the European integration. We have the problem, the sad news that we see every day about the Belarus and Poland border, and the problem with Ceuta and Melilla. It's there, and we have to provide a remedy. We have to provide a European remedy. I just have 5 minutes, and in these 5 minutes I want to add something else, which is the conference, the future of Europe. In general, we are not receiving quality contributions, academic contributions that really create a roadmap. So I hope that you, with your work, with your academic excellence, and with your hard work, you contribute to this topic, solidarity in the European Union, because that way you will be given a qualitative jump with regards to solidarity, because it really it is linked to the Charter of Fundamental Rights of the European Union. And I want to say something that Miguel has heard many times. Maybe you need to have it into account in your future career and your personal career. It is a quote by SUSANA Tamaro, and I also used it at the beginning of my PhD thesis, but you can use it in every realms of your life. When you feel lost or confused, think about the trees. Remember how they grow. Both the roots and the cup and everything will be growing together, and one day you will be covered in fruits and flowers. This is a magical place. The Yuste Foundation is a place full of what is best. And the process for the integration of Europe is made every day. Being a European citizen means a lot. We have duties and rights. You will be taking the relay of the process for the construction of Europe with a key topic, solidarity, with a key value, solidarity, that is intertwined with all the policies of the European Union. So it is responsibility. It is your responsibility. We are now building Europe together, and I just want to give the floor to Nuria. Thank you.
Bueno, en primer lugar también...
Thank you. I want to thank the Yuste Foundation for this opportunity they have given me. We are making the best use. We are making the most of this. I am very happy to be able to hear so many perspectives about the notion of solidarity, a value and a principle that I firmly believe in. And thank you, Susana del Rio, for your kind words. And I hope we'll have time to discuss this topic. First of all, I want to explain why I chose this topic. In my PhD, I studied the non-refoulement principle in the European Union, and I wanted to study the borders of Ceuta and Melilla, which is also linked to the creation of the Schengen area and the principle of solidarity within the European Union and within the European immigration and asylum policies. And I wanted to link this principle of solidarity to the management of the south border of the European Union and the respect of the non-refoulement principle. And of course, the problems in the border between Poland and Belarus is also a hot topic, and sometimes, well, it is having some traits and characteristics that we didn't see in previous migration crises in other borders. But I want you to remember that border conflicts happen from time to time, quite frequently, not only at this border of the European Union, but in many other places, many other borders, and then we forget about them until another one arises. There was a problem in Ceuta in May this year with Morocco. In the Canaries, for these past 2 years, there was an increase in the number of people arriving there, the problem with Greece and Turkey. So the European Union has been strengthening their borders, their outer borders, the expense of the protection of the refugees' rights. So for many years, and after 9/11, the rationale that subdued the approval or the passing of migration policies and acts is a stronger one, one of more protection of the outer borders. So as I was saying, it is important for me when analyzing these borders of the European Union to take into account the standpoint or the turning point of the Schengen area creation in 1985, when the inner borders were abolished and therefore the outer borders were reinforced. And I have a few examples of the Spanish opinions and the crises that have impacted Spain since the creation of the Schengen area. For example, in recent years, the European asylum and migration policy has evolved over time after negotiations that were fruitful or not fruitful at all. And one of the risks of the adoption of these policies of the European Union and the advancement in order to try and create a common asylum and migration policy, which is not common at all, was the risk of respecting the non-refoulement principle, which is the cornerstone of this policy and the creation of the European Union. So there are more and more difficulties for the people to enter the European Union. People who are in need of international protection cannot get asylum because, yes, there is the right to seek asylum, but you don't have the right to get the asylum. There is no guaranteed right to get the asylum. It has not been recognized. So as I was saying, the creation of the single markets and the abolition of the inner borders reinforced the creation of the outer borders. So I want to explain this process. The creation of the SECA, the European System for Asylum, was based on the provisions and the duties and obligations of the Convention, the Geneva Convention of 1951, that was signed by Spain as all the members of the European Union. And of course, this entails a series of duties and rights. They have to respect the duties and they have to take into account those duties in their respective national asylum policies, especially Article 33, the non-refoulement duty. The signatories of the convention cannot return a person to a place where their physical integrity is in danger. The European Union, when it passed the Lisbon Treaty, Article 74 sets this SECA, the Common European Asylum Agreement, and the principle of responsibility. The speaker excuses herself, the principle of solidarity, and equal distribution of refugees among the member states. So this non-return policy not only appears in the Article 33 of the Geneva Convention, but also in other treaties and rules and regulations that have been signed by the European member states. For example, Article 6 and 7 of the Pact for the Political and Social Rights, and many other covenants. For example, the Torture Convention, Article 3 of the European Convention for Human Rights is especially relevant, so I will talk about it later. There is a provision against torture, and it has been deemed to include the obligation of non-refoulement and other articles in the Charter of Fundamental Rights of the European Union, Article 18. And finally, asylum laws, national asylum laws, and the national regulations. And now I would like to briefly talk about the evolution of the European asylum and migration policies from the point of view of the development of the external dimension of those policies and how they have integrated or not the duty of solidarity, which is, as I was saying at the beginning, the prevailing one, the one that had to prevail when creating these policies, because the Geneva Convention in the preamble says that states have to cooperate internationally to distribute the responsibilities and the duties so that they are equally distributed in terms of access to international protection of refugees. When the European Single Act was approved in 1986, the integration of the migrants started to be a reality. And then the Dublin Convention, which then became a regulation, has been openly criticized because it doesn't respect the duty of solidarity, because it imposes more responsibilities on the border states when studying the asylum-seeking applications of people who want to enter the European Union. In 1992, migration and asylum were included in the Maastricht Treaty, and in 1997, the Treaty of Amsterdam included also provisions for asylum and a legal basis for the harmonization of the asylum policies in the member states. In 1999, the Tampere process started to implement policies for the third countries on the matter. They established that in order to create a real common asylum system in the European Union, collaboration and cooperation with third countries is critical. But what type of cooperation or collaboration? That is a key question. I will try to analyze it in further detail, because normally the cooperation is based on border management, and it really doesn't monitor or protect the human rights. Between 2000 and 2005, in parallel to all these, there was the first phase of the common European asylum system, and a series of a set of rules were harmonized. In 2002, the Seville Summit saw how the United Kingdom and Spain proposed a series of aids for cooperation promotion to prioritize and handle the outer borders. In 2003, in the Thessaloniki European Council, the cooperation with neighbor countries was established. Then in 2005, there was a camp, the agreement that included migration policies for Africa and the Mediterranean, and mobility partnerships for some countries in Africa, in order to create a closer cooperation for migration management. Between 2005 and 2009, with the Hague Programme, the importance of setting up equal distribution of refugees among member states was reinforced, was stressed, and also they stressed and reinforced the control of the outer borders, in order to abolish the inner borders. In 2008, the Migration Pact was passed, and they recognized that they could not accept all the migrants. This is something that we have heard many times. Many people say we are not in the position to be able to accept all the applications for asylum. But if we compare the number of asylum-seeking applications and the number of asylum seekers that are accepted by, for example, Lebanon, is very small. Lebanon or Afghanistan, Iran, Pakistan accept many millions of refugees, having a smaller population than the whole of the European countries and many specific European countries. And this is a perspective that is not sufficiently taken into account. And between 2010 and 2014, with the Stockholm Programme, the European Union approved a set of specific regulations and rules to implement this program in Stockholm, by emphasizing the need for solidarity and cooperation, so that we can have a common European asylum and migration policy. In 2011, the Global Approach for Mobility and Migration was approved, and in 2012, the second part of the CEAS was approved. In 2015, as you know, and as other colleagues have mentioned, the refugee crisis took place. It is true that many refugees started to come to the European border, especially people coming from the Syrian war. This is true, but the numbers of refugees were not so high. We could not talk about a crisis. We could not say it was a crisis. The crisis is in Turkey, in Lebanon, in Iraq, in Syria, of course, but not at the European border, because the numbers are not so high. It is a crisis of solidarity and not of refugees. Well, anyway, the European migration agenda was approved, and it wanted to prevent the arrival of illegal immigrants. Yesterday, the President of the European Commission, in a meeting at the European Parliament, said that the solutions to the crisis have to include the illegal immigration, and they have to be returned to their countries of origin, and we have to reinforce the outer borders. This is always the reply when trying to face this type of crisis. In 2020, the new Pact for Migration and Asylum was passed, was approved. I don't want to talk about it much, but it includes a series of rules that are quite alarming from the point of view of the solidarity, because the notion of solidarity is flexible, and I don't think it respects Article 80 of the Treaty of the Functioning of the European Union. This is something that we discussed yesterday, the collaboration for distributing responsibilities, for sharing responsibilities, only focus on how to return the refugees, but not on how to harmonize the asylum systems and to relieve the pressure some member states have. Those who are at the outer borders of the European Union, but I don't want to talk about it. Anyway, this is just a proposal. They are discussing the proposals at the European Parliament. Article 80 of the Treaty for the Functioning of the European Union and the duty of solidarity in matters of asylum and migration, it should improve the functioning of the CEAS. Nevertheless, the notions of solidarity and equal distribution of responsibilities are not defined in detail. So this creates some confusion when trying to integrate the provisions of this article into the CEAS. In the Treaty of Lisbon, it is stated that solidarity is one of the bases for the relationship between the European Union and third states. So it has to regulate both the inner and the outer affairs, the internal and the external affairs of the European Union, both in terms of economic support, material support, and capacity building support, and asylum seeking support, and the allocation of refugees. And one of the things this Article 80 does not have into account is the vertical relations of the asylum seekers. On the other hand, we are seeing that the external dimension of the CEAS is now deemed to be like the external definition of the borders. Professor Crisp says that it implies accepting or passing some measures that will be applied outside of the borders in order to prevent the asylum seekers and migrants to get to the borders of the European Union if they don't have a prior authorization to get closer to the European Union. So the outer borders is not in the physical border, it is going further away. For example, the southern border of the European Union is not between Spain and Morocco, but it is located somewhere near Senegal or Mauritania.
muestran que las personas que llegan a la Unión Europea por la vía irregular, el 90% de ellas después solicitan asilo en la Unión Europea. Por lo tanto, esta óptica que os comentaba antes de tratar de adoptar las políticas de inmigración.
So this perspective of trying to adopt policies considering that these people, these asylum seekers, don't deserve this international protection and they are irregular migrants, that they don't have the right to access the European Union, does not fit reality. One of the ways of having this outer action or this outsourcing of the borders, this is done through agreements with third countries. And I want to mention the agreement with Turkey in 2016 as its response to the migrants crisis in 2015, the so-called migrant crisis. These type of agreements usually are not very transparent, they're usually not public, and as I was saying, it is always questioned whether there are any clauses or mechanisms that are introduced and to oversee if such countries are really ensuring the human rights of those asylum seekers. In the case of the European Union and Turkey, first we need to take into account, we have to think about what we think about when we're talking about a safe third country, because sometimes to justify the return of asylum seekers or migrants to a country outside the European Union, this country has to be considered as safe country. According to the procedures, these safe third countries are defined as countries where people don't see their lives threatened as a consequence of race, religious, sex, etc. And countries where there is no serious risk of damage like inhuman treatment, abuse, etc. And where there's not going to be unlawful return. Also, in those safe countries, there should be the possibility to seek for asylum, according to the Geneva Convention. In the case of Turkey, we must wonder whether Turkey is effectively a safe country. It is true that Turkey signed the Geneva Convention, but there are geographical limitations. In the case of Syrian refugees, most of the asylum seekers, they just have a temporary status, and there are documented cases of Syrians who have been returned to their countries before the conflict finishes, and we have to take into account that there are Turkish refugees in other countries. So once again, we have to think, is Turkey a safe country? Also, on the other hand, this agreement of the European Union with Turkey was passed without following the procedures, the European procedures, which in our view is not correct. As Moreno Lanz was saying, I like the concept that she uses. She talks about an outsourcing of solidarity, not only an outsourcing of border management to other countries, but also solidarity itself is outsourced to countries where we don't have any guarantees that human rights are protected, and countries, and we know we have the principle of solidarity understood in international way, solidarity with refugees. Now I would like to talk about the Spanish example, because as I was saying before, Spain in the field of migration and asylum policies, due to our geographical location, has had loud voice and has had to adopt measures for many years, more specifically since it joined the Schengen area in 1991. Ever since then, the south border started becoming stronger, that is Ceuta, Melilla, and all the maritime borders. Since the end of the 80s, the first boat migrants started arriving through the Gibraltar State. And there's another interesting aspect that I didn't want to elaborate on. What we understand now as the walls in Ceuta and Melilla that you have probably seen in the media, we have those triple fencing that sometimes having erasers. All these fences are relatively new. This didn't exist when Spain joined the Schengen area. The borders were just a regular wall and people came in and out pretty frequently. And people from Melilla say that there was no problem, no migration problem. People just came in and out and that was it. Then afterwards, after the outer borders were strengthened, they started becoming fortified. And we have seen how people have even died trying to cross these walls. In the 90s, the arrivals to the Canary Islands started becoming more frequent because of the CIVE, the outer border control. And afterwards, since there were more arrivals to the Canary Islands, the CIVE, this area, was expanded to the south of the Canary Islands, and people started trying to access through the walls in Ceuta and Melilla, creating the 2005 crisis. The control of those areas was increased, so people went back to trying to access through the Canary Islands. And in 2006, we had the Cayuco crisis, the migrant boat crisis. So a series of operations were implemented with the cooperation of Frontex, the European Border Patrol Agency, and agreements started being signed with third African countries like Senegal, Morocco, or Cape Verde, even Guinea-Bissau. That's when the Africa plan started being passed that involved more cooperation with African countries, a cooperation between Spain and African countries, with an approach to manage borders and try to prevent the arrival of people to our own borders. And that takes us to 2015. In 2014, there was another increase of arrivals through the walls in Ceuta and Melilla. In 2015, the Spanish government decided to pass a measure that I will explain further. In Ceuta and Melilla, some offices were open, and these offices are in the Spanish territory. This is something that we have to bear in mind because the problem that migrants and refugees have in Morocco is that they cannot exit Morocco to arrive to these offices and seek for asylum once they're in Spain. And these offices, these asylum-seeking offices, are in Spain. I'm going to try to speak slower because it's difficult to interpret. Going back to the European Union, in terms of the relationship between Spain and Morocco, of the European Union and Morocco, is that since the year 2000, negotiations started to pass a readmission agreement with Morocco. These negotiations are still ongoing. Morocco is a preferential partner of the European Union, and in 2013 an agreement was signed between the European Union and Morocco that was relaunched in 2019. In terms of Spain's relationship with Morocco, that has historical roots and that has translated in and has reflected in different aspects of our life, I want to mention two milestones that are important in my view. One is the signature of the Spain-Morocco agreement of 1992. This agreement establishes the criteria to return Moroccans in an irregular situation to Morocco. And this is important because often Spain has justified these automatic returns in the borders and at the fences, saying that these are done under this agreement, because that's not true. Because the agreement establishes that for someone to be returned to Morocco, several criteria need to be met, like the return procedure, the identification of the person, or the possibility of accessing international protection. As for the situation in Morocco, from the perspective of whether or not Morocco can be considered a safe country, we must say that Morocco has signed different human rights protection treaties, like the Convention of Geneva or the International Convention Against Torture or the Political and Civil Rights Convention. But this doesn't mean that Morocco is respecting this treaty. Then we have law /2/3 that regulates the stay of foreigners in our country, but this law does not establish any type of anything that is favorable for Moroccans. And this law sanctions with fines or prison foreigners that are in an irregular situation. In this regard, we have to mention the situation of foreigners and migrants or asylum seekers in Morocco who are waiting to cross the border and arrive to Spain, and they have difficulties to access this protection in a safe country. These people are often in places near the border of Ceuta and Melilla, for example, in forests. They camp in forests, and these forests are constantly raided by the Moroccan army forces. Sometimes their tents are burned, they get arrested, and it is very shocking, the situation of pretty large groups of women and girls who are in a situation where they can be trafficked. And we are talking about children whose futures have been lost, who are not schooled, and who are in terrible situations. Often these people are returned to the desert or even to the border with Algeria. Since 2005, in the border of Ceuta and Melilla, there have been jumps and attempts to cross the border. We're talking about people who cannot access Spain through other means. When these people are arrested, they're automatically returned to Morocco. This is what is known as returns in the heat. We say in Spanish, devoluciones en caliente. Professor González García defines these returns to a de facto return of people who have been able to cross the border through unauthorized points. The Spanish regulations already includes these cases of people who are in an irregular situation. However, in 2015, the Spanish government decided to introduce a new concept in this regulation known as the border rejection that tries to make these returns legal. These border rejections have been criticized by many human rights organizations like the Ombudsman or the Council of Europe. The ministry, this refusal of entry has been criticized, as I was saying, and there have been suggestions to change the situation and to create a protocol. This refusal of entry and the law, the organic law of citizens' protection, was taken to the courts, and in 2020, the Supreme Court decided that this refusal of entry is legal and that the situation of Ceuta and Melilla has to be taken into account. However, the court decided that this can be considered legal as long as there's a full compliance of international law and other measures. This is not the case, and I will explain this further later on. It's also important to take into account the operational concept of border, because I think it illustrates really well what we are talking about, this development of the external dimension of the migration and asylum situation. And this is a concept that illustrates very well the outsourcing of the borders. Based on this concept, the Spanish government considers that people who are trying to access Spain through the fences have not accessed Spain as long as they don't touch Spanish ground, or as long as they are not found by the armed forces. So this is ignoring the borders with Morocco that are duly established in the agreements signed with Morocco, and the Constitutional Tribunal and the European Tribunal of Human Rights has stated that Spain cannot move borders at its will, but that there are established agreements if borders want to be changed, and that's not the case. Borders are not to be changed. As I was saying, it's interesting to analyze Spain's responsibility on these practices of these returns from the point of view of human rights and international treaties and international norms that Spain is signatory of. refusal of entry at the border should only be done as long as international protection and human rights are respected. First, and from the perspective of the obligation of non-return that is included in Article 33 of the Geneva Convention, this Article 33 has been construed in a broad way, including borders. So refusal of entry would be forbidden if Article 33 were respected. Article 6 and 7 of the Political and Social Rights Convention and the Torture Convention protect against this type of refusals. These last three articles increase the implementation scope of the Geneva Convention because they can be applied to many more people than the Geneva Convention, and in connection to the territorial, these have an extraterritorial scope, and this is important when we analyze this subject from the borders. In terms of the Regional European Convention, we have to bear into account Article 3 of the European Human Rights Convention because it creates, this convention creates real rights for migrants and refugees. This convention does not regulate migrations or asylum, but the construction of this article has turned it into one of the most favorable regulations for migrants. More specifically, Article 3 and its use for borders or foreigners in general. We have the sharing case, and we also have other cases like Sahalo Seriyama. This is an absolute article that should not be infringed under any case, and this means that the implementation of this article is stronger than Spain's right to control its borders. This article also forbids chain returns. Spain must guarantee that it doesn't return someone to a place that may seem safely, but from which this person can be returned to an unsafe place. This article also includes the Geneva Convention, and it can be implemented extraterritorially. At this point, I would like to analyze and expose the case ND and NT against Spain because it's very relevant to what we are studying. Decades have gone by since tribunals have been able to rule about what's happening in the walls of Melilla until the Human Rights Tribunal had the occasion to analyze the cases of ND and T from Mali and Cote d'Ivoire, who were returned to Morocco because it infringed Article 3 of the Human Rights Convention, the one that I just mentioned, and Article 4 of Protocol 4 that forbids collective returns. In the year 2017, the European Human Rights Tribunal condemned Spain, but in 2017 it acquitted it, which was very surprising for the academia, civil society organizations, and in general. This ruling does not analyze the implementation of Article 3, unfortunately, because it considered that the claim was not duly fundamented. It recalls the importance of the non-return principle in terms of the management of outer borders, but it does not sentence or condemn Spain. Also, the tribunal establishes that NT and ND put themselves in a situation of illegality because of their behavior, because they knew that they could not access Spain through the legal ways, and they decided to break the law, and that's why Spain is acquitted. The tribunal also debates the use of strength by these people, but the people who accessed those that third wall were not that numerous, and this is documented through videos. The tribunal is basing the implementation of a human right on the behavior of an individual, and that's very dangerous. We're talking about people who are not committing crimes. Those are administrative sanctions, and often they have fewer rights than those who are committing crimes. On the other hand, the Strasbourg Tribunal establishes that they could have accessed legally. They could have asked for a visa in their home countries, in other countries. They could have used the consular services in the transit countries, or that they could have accessed the asylum offices in Melilla. As Carrera documents in a very interesting article, it's virtually impossible for people from Mali and Cote d'Ivoire to access any working visa, and this is something that everyone knows. On the other hand, although it is true that the asylum law regulates the possibility of asking for asylum in consular offices, this article is barely implemented, and when it's implemented, it's for family reunification. And also, as I was explaining, the asylum situation in Morocco is fragile. Asylum seekers in Morocco are followed by Moroccan officials. In terms of the potential access to asylum offices in Melilla, it's surprising that these offices opened in 2015 and the tribunal was ruling on something that happened in 2014. And it's impossible for some people to leave Morocco based on their citizenship and, unfortunately, based on their skin color. People from Mali or Cote d'Ivoire or any other country from sub-Saharan Africa can't even approach the border because it's under extreme control, so they cannot access Morocco to ask for asylum in Spain. This ruling was a very sour blow for many of us, but a few weeks ago, the European Tribunal of Human Rights sentenced Croatia on a similar case, and in that case, the claimants didn't have the access to any other legal way, so Croatia was returning these people in unlawful ways. So this is a little bit of hope. This gives us some hope. The European Union hasn't condemned firmly enough the refusal of entry, and Spain has been mentioned as an example of migration and asylum policies. The refusal of entry infringes the rights in the CEAS. This refusal of entry is in violation of even our constitution, because and our laws, because these people don't have access to lawyers or an interpreter. They have fewer rights than people who have committed an actual crime, who have the right to remain silent, among other rights. And to wrap up, I want to mention that I thought it's important to repeat the concept of solidarity, to remind that it's a concept of solidarity that must guide the implementation of border control policies. And the tribunal, the European Tribunal, has said that solidarity is the purpose of the European Union, as mentioned by many general advocates. Monet said that Europe, and Schuman and Monet said that Europe should not be built in one day or overnight. And hopefully, in terms of our migration and asylum policies, we will be able to integrate the concept of solidarity. Solidarity, especially with those who are in need of international protection, because the obligation of solidarity should be implemented both internally and externally. I want to emphasize that it is an obligation. The outsourcing of borders goes absolutely against this solidarity, and the refusal or the return in the border infringes many human rights. And I'm going to leave it here, but I want to mention the case of Ibrahim, someone from Mali that I met in Melilla. He was 20 years old, and he was able to access Spain after trying to jump the fence 3 times. He had injuries everywhere in his body because of the blades in the fences. After 3 times, he was able to access Melilla, and he was caught there after jumping the wall, and he was returned to Morocco, to the desert. He had been waiting for years in Morocco, trying to get the asylum, and in his third attempt, he was able to jump he was at the top of the wall, and he was returned to Morocco. And finally, he was able to make it to Spain, and when he was at the center, at the detention center, he was finally able to ask for asylum. So we see that if these actions that are happening is deterring, it's a deterring measure, I think it's not working, because we can see that the outer borders, in the outer borders, we see that people won't stop migrating and people won't stop looking for a safe place to live their lives. Thank you very much.
Bueno,
Nuria, I want to congratulate you. I applaud you, and after reading your work and after listening to you, we can see what I said in the minutes when I presented your work, your wonderful research work. You know how to put together the comings and goings of the evolution of what has happened in connection with European migration and asylum policies. So you put all these facts together, and at the same time you introduce permanently some present-day topics, human and humanitarian topics that really give us a perfect sequence of how policies evolve in connection to these so important topics that are at the heart of the European Union itself, because solidarity is a value, it's a seal and a brand of the European Union. And as we're seeing these days in the presentations of all our works, if the European Union can raise its voice about something, it's on the capacity that it has to rebuild itself. So the book that I have the honor of having published with the Yuste Foundation, together with the Peter Lang publishing house, is called Europe Project and Process: Citizens, Democracy and Participation. And I'm saying this because of the following fact. I have several questions here, and one is that really in this outsourcing of borders that you're talking about, and you call it outsourcing because it's really an outsourcing of the borders and of the common policies. We're talking about European common policies, but that doesn't exist. It's not made. That's why it keeps being infringed, both by member states and by the failure to act and failure to make decisions of the European Union itself. So there's this infringement of a principle that is in the Charter of the European Union that is legally connected to the Lisbon Treaty, and at the same time this is connected to a fundamental value of our European Union. Without solidarity, we're not the European Union, because European Union is solidarity, and the integration process means solidarity, and being European citizens entails something as precious as raising our voices and being in solidarity. So in this shared responsibility, I think that we are, let's think about what we're seeing in the Russia-Belarus border. And I want to mention something unconnected to what Pablo said. We know that there has been resolution by the European Parliament for Poland to, for the European Commission to fulfill its worth to connect the rule of law to its permanent safeguard, and to connect it to receiving or not receiving European recovery funds.
And a week ago, a fine of 1 million euros was imposed. So I was wondering to myself, how can we really set conditionality? I'm in favor of the conditionality and the audits to the member states if they will not comply with the principles of the rule of law. But now Poland, which is part of the European Union, says we have this problem in our external border. What can I do? And the European Union has to do something about it. So my question is, well, my first question. So this auditing, this conditionality, this auditing of the member states, if they do not comply with the principles of the European Union and with being a member state of the European Union, Nuria, do you think we could put some clauses of conditionality on those member states if they don't comply with the Charter of Fundamental Rights and if they don't respect the human rights? Because you know that the Charter of Fundamental Rights came into force and is currently into force with the current treaty. My second question is the pact. The personalized European Pact for Migration of the European Union, in my opinion, is not acceptable in the European Union. It's been now and is under discussion. And do you think that the European Councils, the decision-making process of the European Union, a qualified majority, is useful to render the policy-making more agile? Do you think it would be positive on the member states? Do you think they could overcome their selfishness and understand common shared sovereignty instead of basing their sovereignty on selfish national interests in such an important, humane, and important and human topic, which is the Migration Pact? And I also wanted to say that there is a debate going on regarding the fences, the wall. If we can build a wall between Poland and Belarus with the Next Generation EU funds. They said no, but Charles Michel, the president of the council, started to talk about the wall, the length of the wall and the height of the wall to be built in 2022. What do you think about it? Your work is excellent. It's an honor for me to have presented you, to have introduced you. And I want to quote William Ball Yeats, that Pat Cox used on the opening of the convention for the drafting of the European Convention. This is a quote that it can be used by all of you, all of us, in our responsibility to build a European Union, a union of unions. He said, "I've put my dreams at your feet. Please be careful when you walk, because you are walking over my dreams." I think this sentence, this quote is great because it really covers everything. Thank you, Nuria.
Bueno, muchísimas gracias de nuevo por tus amables palabras.
Thank you again for your very kind words. I loved the two quotes that you have used. They are inspiring, so thank you again. As for your questions, the first one, conditionality and audits to the member states if they do not comply with the principle of solidarity or they don't respect the human rights or the provisions of the Charter of Fundamental Rights of the European Union. Well, I think, yes, there are some mechanisms that can be applied in case of these type of violations, but the European Union, as I was saying earlier, with the refusal of entry, has not condemned officially or enough these kind of violations. So it's like everything becomes blurred in the borders, and in my opinion, it shouldn't be like that. Especially if we have into account the history of the European Union. In the past, the Court of European Justice, I don't remember the exact judgment, but it condemned Serbia, Poland, another country for not accepting the refugee quotas. And I think Serbia, in the European Union versus Serbia, in December 2019, was also condemned by the European Court for not accepting the quotas. So the problem is that we have the mechanisms, but we don't put them into action. We don't execute them or enforce them. Regarding the second question, the pacts, I think it's a matter of flexible solidarity also with the third states. Regarding the qualified majority instead of unanimity to render it more agile, I think it's a good idea. This has not to do with the pact, but the directive for temporary protection that has never been activated, even if I think it's a very good instrument to control the massive affluences that now will be probably replaced by another mechanism. It has been criticized because it has never been activated, and it has never been activated because it required unanimity. And maybe it should be, the unanimity should be replaced by a qualified majority, which should be okay for these types of cases. Marelli this summer suggested using that directive for the refugees coming from Afghanistan. So we have the mechanisms, we have them, they are good, and sometimes they are not enforced, like always. It is difficult to find the balance. And regarding the wall, if whether we can build it with the recovery funds, well, I have to study these funds in further detail, otherwise I can ask Pablo. But in my opinion, no, we can't use them. I can even think of it. My image of a wall is the tribal fencing of the Ceuta and Melilla borders that I was explaining before. It is quite an impact. It is quite striking. You can have a border, but putting that kind of things in a border, which are dangerous and harmful and painful, is a completely different thing. So I don't think you need those mechanisms for people who are just fleeing their countries in danger. Of course, I'm not defending the use of those devices for people who have committed crimes or offenses, but let alone for people who are just fleeing their countries because they're in danger. If I study the process of the funds in detail, probably I will give a more elaborate answer. Thank you, Nuria. I totally agree with you. We have 3 questions on this side. Miguel was saying to me that we can have a whole round of questions and then you can answer them together. We have a question by Esther, Patricia, and well, it's a comment or a question. I am a politologist, so I want you to understand my position when I make my comments. I'm not a lawyer. Well, I understand you. I agree with you, and I agree with your starting points. I agree with your opinion, your take on the conventions and the policies, and I agree with you that the outer borders are being reinforced. But to complement your work, I would say that from a methodological point of view, the work is excellent. But, for example, maybe you should include something else. You have lots of information, so maybe you could explain what type of databases you have used, what type of sources have you based your work on, because you haven't mentioned it sufficiently. We cannot see it anywhere. So you should mention them in your paper or in your exposition. Sometimes you are talking about personal experiences, but have you used official service, in the case of Ceuta and Melilla, for example, that can sustain your conclusions? It is important also to explain why you chose Ceuta and Melilla, because it wasn't clear to me. When you select examples or certain cases, you have to detail why you choose them. I can think of several reasons for you to choose it. For example, because there are peripheral borders, as such, they are quite specific and quite unique, and especially for Spain, for Spaniard. For example, in the title, you talk about the management of the southern border, but in your exposition, you explain the legal basis and the documents, but you don't talk about management of the southern border. In my opinion, you do discursive institutionalism. You highlight the ideas of the government on the migration policy, but you're not analyzing their management abilities. You can even modify the title because it could be confusing. It was confusing to me because, in my opinion, the title should be, or at least that part, the capacities that governments have to handle the borders. And, well, my last comment or question. A relevant question is the issue of the political differences, because probably there are no significant political differences in Spain between the Socialist Party and the People's Party and the subject matter. But if there are, you have to explain them. You have to think about it. That could be quite relevant. And, well, I leave it to you. But one final question that summarizes it all. I agree with all the tenets, but in the end, I don't understand whether this is an administrative issue or a political issue or a combination of all these. Thank you. Thank you, Esther. Please, Patricia, you have the floor. Nuria, congratulations, because your exposition was brilliant. It is a very hot topic, and since you are an expert, it was a pleasure for me to listen to you. But I wanted to make an appreciation. If I got it wrong, maybe you can correct me. You said that 9/11 was a turning point, and I totally agree with you. You've talked about safety, Safety is something very important in my field, but you have talked about safety and security, and you said that it limits the rights of certain people, which leads to a reflection. So after 9/11, how that safety or security materialized in your field? For example, in my case, which is the aircraft safety or aircraft law, it changed completely. And then you talked about safe countries. Maybe we should rethink the concept of security, because we can say that security prevails over the dignity of the migrant people and asylum seekers. I am reluctant to think about security like that. The way I perceive it and the way I conceive it, because it prevails over, well, security is critical in my field, but does it really prevail over the dignity of those people? Should we rethink our notion of security, as SUSANA said? And finally, you said that the borders in many cases blurs the rights of the people, and I was struck to see it, to understand it. How can I channel all this information? Because of course, for states, the national security and the security at the borders is critical. Vanessa, well, Nuria, first of all, congratulations on your presentation. I think it's a convergence between a legal research with a legal basis and at the same time your field experience, your field work. So this work is quite interesting because of that. But you said in your presentation that the turning point in the migration policy of the European Union was the decision to create the Schengen area. The Schengen area was undoubtedly a reinforcement of the principle of solidarity within the European Union. But the consequence, the practical consequence, was the reduction of this solidarity towards the rest of the outside of the European Union. You said that before Schengen, the Schengen area, there was no border between Morocco and Spain, for example, or the border was not visible. So how can you explain that reinforcement of the inner solidarity has created an imbalance with the outer solidarity? Being it that solidarity is a principle of the European Union and the Europeanness. So Nuria, you can take all those questions and start replying now, but please be brief. Thank you. Thank you for your suggestions, comments, and questions. I have to take into account the methodological approach. It is true that sometimes I have problems to limit the material that I have. Of course, in my PhD dissertation, I explained all the methodology, and I can add it also to this paper. Regarding the use of surveys, I don't know of any survey in Ceuta and Melilla. I know there are qualitative researches, but I don't know of any quantitative researchers or researches. I will look for them. I will try and find some that would be very interesting, but it would be controversial and sensitive at the same time. I chose Ceuta and Melilla because I had personal reasons. In 2015, I was conducting research on both sides of the border regarding the rights of migrants and asylum seekers. The refusal of entry had just been approved, so I decided to go to Ceuta and Melilla. But it is true that it is also relevant because of their geographical situation, the only land borders of the European Union that are located in Africa. Which does not mean, as Professor Javier de Lucas said, that they should be under permanent exception. He uses that expression, and I do not agree. And about the political differences, at least in what I have studied, it doesn't matter what political party is in office, because one party approves the refusal of entry and another country imposes the principle of anti-constitutionality. Well, they do similar things, so it doesn't matter. And the hard returns have been practiced by both political parties, by both governments. So sadly, it doesn't matter at all. Regarding the security after 9/11 and the notion of safe country, this is under constant discussion, and many people are asking for it to be approached. I think we have to be careful with it. It has to be, many people ask for its repeal, for its abrogation, or for it to be revoked, so we have to be very careful. And finally, the disappearance of the inner borders and its consequences on the outer borders. Yes, there are some rights that are only for Europeans only. For example, freedom of movement seems to be only for Europeans, and for the rest of people, even if they are within the European Union, they are not free to move around. So they belong to a different category of nationalities, so it seems. So it affects everyone, but it affects especially the non-EU nationals. So for us to have freedom of movement, others do not have that freedom of movement or entry into the European Union. Thank you. Well, Nuria, this is great because you know that the awardee of the Charles V European Award last month, Angela Merkel, did good politics with the refugees, with the Turkish migrants, and so he went beyond the policies of the European Union and did what she thought should do. Thank you.